Hi, everyone in Paris. I hope you're getting this. My name is Antonios. Sorry for not being there with you today. And unfortunately, I'm stuck in Oxford doing admissions interviews, which is far less fun than it would have been to have been in Paris with all of you. Thanks to Charlotte for inviting me to give this paper, even if I have to do it over video, which is slightly awkward, but I'll try. Essentially, Charlotte asked me to talk about unilateral extraterritorial sanctions and the challenges they potentially pose to the principle of sovereign equality in international law. And you'll see that in a way, I don't think that they pose a problem or a challenge to the principle. They are effectively inherent in sovereign equality in a way which may well be a criticism of the principle of sovereign equality, but that's another matter. But first things first, what do I intend to do over the next approximately 15 minutes? I suggest that I first discuss the terms briefly, so the term sanctions and the term sovereign equality, so that we all know what we're talking about, or at least you know what I'm talking about. That's going to be the first part of the discussion. In the second part, I will try to explain why sanctions, as I understand them, are an inherent feature of the principle of sovereign equality. As a main method for what is essentially formally equal states to implement state responsibility and to enforce international law. I will then move on to try and show or discuss some of the problematic cases of sanctions, in particular extraterritorial sanctions, and when extraterritoriality renders sanctions unlawful. Then, based on that analysis, also briefly discuss denial of immunity as a potential sanction, and whether it would be wrongful or lawful. And then perhaps say a few words on standing, if there is time, and on the so-called sanctions in the collective interest, as it were. My conclusion after going through these three steps is essentially that if something actually does qualify as a sanction, then it doesn't pose a problem to the principle of sovereign equality. But perhaps the principle itself poses the familiar problem that legal equality poses when it is faced with factual inequality. Yes, of course, all animals are equal, but there are some animals that are more equal, as it were. So let's start with the section on the terms and what I propose to discuss. Unilateral sanctions. I mean, unilateral sanctions, and generally the word sanctions in international law is not a technical term. It is a technical term in law, but not a technical term in international law, in the sense that it is being used in a manner that's very fast and loose. A sanction in law, I understand as the necessary complement that backs up a particular command and thus creates a legal rule. So the two elements of a legal rule being a command backed by a coercive sanction. And the traditional sanctions, in inverted commas, of international law in that sense have been or were reprisals in war. Now, of course, since the UN Charter and the prohibition of the use of force, the use of force war has been centralized to the Security Council, at least theoretically, so that's not an issue there. But and the only thing that remains is reprisals, which we now term countermeasures, in particular in order to avoid sort of forcible connotations, because reprisals did have forcible connotations. So these are the sanctions of international law, as it were. So essentially the only sanction of international law that remains is countermeasures to be taken unilaterally. But let's stop there and let's get a couple of things straight first. Any measure that a state adopts, any measure whatsoever, may affect its international obligations, and in that sense, that measure falls to be assessed as against the international obligations of the state. If the measure does not violate any international obligations, then that's where the discussion stops. I mean, you may call it a sanction if you want, or you may call it George. It doesn't matter. The measure doesn't violate any international obligation of the state, so in that sense, it's not a problem. At best, for measures that are otherwise lawful, what you could say is that they might be called acts of retortion if they are lawful, but they are somehow considered to be unfriendly, to put it simply. So an act of retortion is a perfectly lawful but unfriendly act. Retortion can in no way be seen as sanction, even though we do occasionally call sanctions measures of retortion. They can't be called a sanction as I define sanctions because they can be taken at any time and for whatever reason. They don't even need to be responding to an internationally wrongful act by another state, even though they could be taken in response to an internationally wrongful act of another state. And you can think of many examples like this. For example, withdrawal of diplomats, or even breakup of diplomatic relations. Sometimes it's called a sanction, but it's not really a sanction in the technical sense of the term, because no state is under any obligation to maintain diplomatic relations with any other state. So you can withdraw them for any reason and whenever you want. Now, if you're doing it in response to a wrongful act, that's another thing, but that doesn't make it a sanction. It's just lawful conduct, even though it might be unfriendly. If you want another example, the breakup of trade relations with a state. If you don't have any positive international obligation to maintain trade, you can break off trade whenever you want. I mean, the Nicaragua case tells us so, and so on. Withdrawal of aid that you've been giving voluntarily and all that stuff. All that stuff may be seen as unfriendly acts, but they're definitely lawful acts because they don't violate an international obligation of the states taking them. However, if the measure is potentially or is in breach of an international obligation, then effectively in the first instance it is an internationally wrongful act. Unless there is some circumstance of precluding wrongfulness which you can invoke. Here, in this talk at least, we're only interested in one circumstance precluding wrongfulness, and that's countermeasures. Why is that? Because countermeasures as a circumstance precluding wrongfulness are a breach of international, or the breach of international law is justified because it is taken in response to a previous breach by the target state, to put it simply. And only this circumstance precluding wrongfulness can qualify as a sanction. To justify yourself on the basis of necessity or force majeure is not a sanction. Here we have a proper sanction in the sense that countermeasures are breaches of international law, breaches of international obligations that are taken in response to a previous breach by the target state. And this brings us to the discussion of the fundamental, but no less vague for that, concept or principle of sovereign equality. So how do I understand sovereign equality? Sovereignty, for me, in the way that I define it, I'm sure some of you will disagree, but the way that I understand it is as signifying nothing more than la plénitude de pouvoir, since we are in Paris. So basically the plenary power of the state. And plenary power includes the power, of course, to limit one's own power, so the power of self-limitation. So states, through consent, assume international obligations which delimit or limit their own plenary power. So they limit their sovereignty. This power to self-limit is itself an attribute of sovereignty. It's not incompatible with it. In fact, it is an inherent part of it, as the PCIJ has told us already way back in the Wimbledon case. So all states have sovereignty. All states are sovereign, which means that they formally all have plenary power, the same legal power, and hence they cannot but be equal. So this is where sovereign equality comes from. Sovereign equality is nothing but formal equality, equality in the eyes of the law, essentially, in terms of capacity to assume rights and obligations, and in terms of equal access to the law. In that sense, there's nothing sort of mystical or peculiar about sovereign equality. All states are formally equal in the eyes of the law, just like we are all equal in the eyes of the law and in our domestic legal orders. Of course, this by no means signifies also factual equality in the least, and I think that's what's causing the confusion and arguments that somehow sanctions are a violation of sovereign equality just because one state is more powerful factually than another. But I'll come back to that. So why do I think that sanctions are an inherent feature of sovereign equality? Well, states are sovereign and thus equal, as we said, but this also means that they accept no higher authority but themselves. So since they have la plénitude de pouvoir, so states make the law themselves, they interpret the law themselves, and they apply the law themselves, and they also enforce the law themselves. So in this decentralized legal structure that is international law, in this decentralized legal order, where there is no higher authority and no central organ to enforce the law, states must enforce the law themselves. And the only way to do this, and to do this coercively, is through countermeasures. So by seeking to induce compliance by the recalcitrant state or entity with the obligations under international law. Thus, sanctions, because only countermeasures can properly be called sanctions, as I said, are an inherent feature of sovereign equality. Every state determines for itself and at its own risk whether it's been wronged, and then proceeds to take certain countermeasures or sanctions, if you want to call them, with a view to enforcing its rights, to enforcing the law. These sanctions, these unilateral, these countermeasures, are in the first instance internationally wrongful acts, as we said, whose wrongfulness is precluded. Now, if the target state disagrees with the assessment that the reacting state has made, then it can undertake its own reaction, and I'll come back to that. But in the end, what we have in those cases, so when the two states disagree, is a dispute, essentially. We have a dispute which cannot be resolved except by the state somehow getting to an agreement, or at least agreeing to submit it to adjudication. And all states have that very same right, so very same equal right. So structurally, there is no problem with sovereign equality when it comes to sanctions. I think the problem lies elsewhere, and I'm coming to this part now. So not in countermeasures in general, so not in the idea of sanctions in general, but in what essentially can be called purported countermeasures, so countermeasures taken by one state, when these are problematic and cause dispute. So the essential question is really not whether unilateral sanctions are somehow sort of a challenge to sovereign equality. They're not. They are basically a way in which sovereign equality operates. But the real question is, does something qualify as a countermeasure? And here is where I come to the problematic cases. And the main problematic case where I've been told to focus on is extraterritorial sanctions. But in order to do that, I have to explain, first of all, what I think extraterritorial measures are. So extraterritorial measures are any measures taken by a state which purport to regulate in some way the conduct of non-nationals outside the state, the conduct of non-nationals abroad. Now, to what extent these measures are in breach of international law can be a matter of contention and a very long discussion. So I'll give you my view. Even if we don't take the Lotus position, or rather, without going into Lotus, you know that how does it work? Do we need a prohibitive rule? Otherwise, everything else is allowed, or do we need a permissive rule? What is the closing rule of the system and all that stuff? I will say that whatever assumption you make, the outer limit of extraterritorial limitation by one state, of extraterritorial regulation by one state, must be the domaine réservé, the exclusive domestic jurisdiction of other states. The prohibition of intervention as a rule in international law relates exactly to this domaine réservé, to this sphere of liberty of states, where states are free to act as they will and where they don't have to suffer intervention. Unfortunately, this sphere of liberty, this domaine réservé, can only be defined negatively, which is what I think confirms Lotus, but anyway, that's a different story. So essentially, what does this mean? It means that only that remains within the sphere of liberty of a state, within the domaine réservé, on which the state has not assumed any international obligation. So there is no irreducible content of sovereignty or irreducible content of the domaine réservé or exclusive jurisdiction, because the state is free to assume any obligations that it wants, even to the extent of committing suicide in the final analysis. But that's neither here nor there. The important thing is that, as such, if we accept all that, an extraterritorial measure is only wrongful to the extent that a state has not assumed an obligation to suffer it. To give you an example, if Greece assumes international obligations by a loan agreement, and these international obligations involve conditionalities about how it is to legislate, the fact that somebody else comes in and tells Greece how to legislate, legally, technically, on the basis of the law, is actually not a problem. Greece assumed this of its own free will. So what will you say? Oh, this is somehow going into the irreducible content of domestic jurisdiction. It doesn't. You gave it away. You made it yourself no longer irreducible. So even, however, it is possible that a measure taken by one state may actually interfere in an area where the target state does not have any obligation to suffer intervention. In that case, the extraterritorial measures is in the first instance wrongful. However, it can still be justified as a countermeasure, because that's the essence of a countermeasure. It's a wrongful act in response to a previous wrongful act. So extraterritorial sanctions can be acceptable if they qualify as a countermeasure. For that, it is necessary to see whether particular extraterritorial measures first of all, are wrongful, and if they are wrongful, do they qualify as countermeasures? That is, do they respect the conditions for taking countermeasures? The most crucial conditions here is, first of all, that countermeasures need to be targeted against the responsible state. So if they affect third states, they need separate justification, and this is what will bring down many extraterritorial measures. And the second, of course, is respect for the principle of proportionality. So extraterritorial measures are likely to be hitting third states which are not responsible, and in that sense, it will be a very big problem to justify them as countermeasures towards these states. You will have to find some other justification. And also, in respecting the principle of proportionality, many secondary boycotts, which extraterritorial measures primarily aim to impose, essentially secondary boycotts, will also fall. So, but this is the analysis that we need to undertake. To bring this to immunities, you can just do a very similar analysis with respect to immunities. So, immunity is a rule that stems essentially from sovereign equality of states, but a denial of immunity, and thus a denial of immunity is a wrongful act. Fair enough. But it could still be justified as a countermeasure. So denial of immunity could be a countermeasure. In fact, we do have some examples of that working out in the field of responsibility of international organizations, because a lot of courts in the aftermath of Waite and Kennedy, a lot of European domestic courts, essentially what they've done is they have started denying immunity to certain international organizations in response to the fact that these organizations do not respect the right to a fair trial. This can be seen as a countermeasure, as I said, though again we need to assess it against the conditions for taking countermeasures, and the really crucial here is the condition of reversibility. Obviously, we don't have time to go into that assessment sort of in the abstract. And finally, if I could say a word on standing, on countermeasures, as they say, in the general interest, so not by a directly injured state. There is no doubt that states that are not directly injured by a breach, but are indirectly injured by a breach, in the sense that an obligation owed to the international community as a whole, or to a group of states to which that state belongs, has been violated, they have standing to invoke the responsibility of the responsible state under Article 48 of the Articles on State Responsibility. Can they take countermeasures? Article 54 doesn't resolve the issue for us, but in very short terms, I can tell you that I think that practice has proven that this is actually allowed. Again, here we will have a problem with the conditions, and in particular the condition of proportionality, because if you have a large number of states taking such countermeasures in the general interest against a particular state, they may be disproportionate. So in conclusion, and sorry that I've taken longer than I planned, I don't think that extraterritorial unilateral sanctions per se pose without else a challenge to sovereign equality. Unilateral sanctions in general are how sovereign equality operates, though of course I accept that countermeasures and sanctions, countermeasures as sanctions, do pose a challenge to factual equality, or pose a challenge in view of the fact of factual inequality of states. These states can still react, they can negotiate with a view to resolving, like China is doing with respect to Huawei. They can just suffer them while yelling about it, which is what Cuba has had to do for such a very long time. They can challenge them before international courts, like Iran is doing currently, or like Russia is doing in the WTO, or finally they can escalate and see what happens, like in the air service arbitration between US and France back in the 70s, which led to dispute settlement before an international court. So I hope this has set a framework for you and that it has made some sense. I apologize for taking longer. I thank you very much for your patience and your and for listening to me. And I'm sorry again that I couldn't be there with you. I hope you have a great conference and that I'll get to hear about it afterwards and consider your comments. Thank you very much.